Then we come to section 28. Agreement in restraint of legal proceedings. Every agreement by which a party is restricted absolutely from enforcing his rights under any contract by usual legal proceedings in ordinary tribunals or courts, or every agreement which limits the time within which he may thus enforce his rights. So here are two components to this section. We are talking of two types of agreements. First type is where the agreement restricts absolutely the right itself to enforce the court, to enforce his right in an ordinary court. And secondly, the right is not restricted absolutely, but the time is limited. In the sense, see, some time limit is given under the Limitation Act. So if a right is to be enforced in a court of law, that enforcement has to be made within the specified time. Time is specified in the Limitation Act. But if the agreement restricts it further, then such an agreement is void to the extent that it restricts the time to a lesser extent than what the Limitation Act provides. So both these types of agreements are void. Here also there is an exception. This section shall not render illegal any contract by which parties agree that any dispute which may arise shall be referred to arbitration, and only an amount awarded in such arbitration shall be recoverable. Now, what does section 28 generally say? That any rights arising under the contract shall be enforceable through an ordinary court of law. Ordinary tribunal means ordinary court. But if the contract provides that in case of a dispute, we will not go to a court of law, but we will get our dispute settled by a process of arbitration, then such a provision is acceptable because it encourages arbitration, and that is public policy, and therefore this exception will be applicable. Such an agreement is enforceable.